Warm greetings to the bench, my lordships. The council is appearing on behalf of the petitioners. The council seeks permission to address the bench collectively as your lordships, my lordships. My lordships. The council seeks permission to proceed with the facts of the case. My lordships. In this particular case, the Union of Himalaya is a sovereign, social, secular, democratic and republic country here, my lordships, and Manastan is one of the southern states of Himalaya. In this particular case, Union of Himalaya is paramilitary to India and Manastan is paramilitary to Tamil Nadu here, my lordships. In this particular country of Himalaya, the criminal justice system consists of the police, judiciary and the correctional system here, my lordships. In this particular state, Varun is a high secondary school student who was fed up with his lifestyle, my lordships, and he started associating with Darun, who was his friend, my lordships, and there was a slight change in his behavior, my lordships. On a particular day of 8th August 2023, Marina, an old woman, was walking on a street, my lordships, and on that particular day, two persons, that is Varun and Darun, snatched their chain, my lordships. And based on that incident occurred, she was met with a grievous wound, my lordships, and was kept in ICU in an hospital, my lordships. On 17th August 2023, an unidentified half-burned body was found near the Parvada area, my lordships, which was later identified as Zena, who was a minor transgender girl, my lordships, and the bike with a tampered number plate was found near the crime scene, my lordships, which was the bike of Varun, my lordships. Based on the motorcycle of Varun, he was arrested and was linked to the chain snatching case here, my lordships, and he was found as an accused in the chain snatching case also, my lordships. Much of my lordships, and the statement from Varun has been taken before the magistrate, and based on the statement, he was granted a bail here, my lordships, and after that granting of bail, the Marina, the old lady who was suffered from the chain snatching case, untimely demised, my lordships. So, in this particular case, the 302 of IPC was inserted to the FIR, and the bail which was granted to Varun was cancelled here, my lordships. So, based on the cancellation of the bail, Varun filed a petition before the Honorable High Court under the section 482 of CRPC here, my lordships, and at the same time, Paramu, who is the father of Zena, was taken a statement before the magistrate court, my lordships, and based on that statement, the court found that the criminal investigation was not made in a proper manner, my lordships. So, the arrest warrant was issued to the investigation officer of this particular case, whose name was Bill, my lordships, and the inspector and the investigation officer of this particular case also filed an petition under the section 482 of CRPC challenging the arrest warrant, my lordships. These two petitions came before this Honorable High Court for the investigation, my lordships. The lordships are well versed in the facts. The council is permission to proceed with the issues raised, my lordships. Much of my lordships. The issues raised in this particular case is whether the offences mentioned in the FIR is made out, and the second issue is whether legal proceedings in the chain snatching case is complied with the criminal justice system, and the third issue is whether the cancellation of bail violating any rights of the offender, and the fourth issue is whether the arrest warrant issued to the investigation officer is legally valid. The first two issues will be dealt with myself, and the second two issues will be dealt with co-counsel, and the researcher is doing some basis of my lordships. Much of my lordships. The council is permission to proceed with the advanced arguments of issue 1, my lordships. Much of my lordships. In this particular case, the first issue arises is whether the offences mentioned in the FIR is made out. In this particular case, the council tried to separate the arguments into two limbs, my lordships. One for the chain snatching case and the other one for the Zena's rape and murder case, my lordships. First, I would like to explain the Varun's chain snatching case, my lordships. In this particular case, no one can deny the fact that the offence is made out here, my lordships. The offence is committed here, but the mere fact is Varun cannot be made liable for the offence committed by the Tarun here, my lordships. Since because there are direct witnesses and the Varun himself agreed that he was driving the vehicle here, my lordship. So, no one can deny that the offence is not made out here. But the offences mentioned in the FIR on Varun is not made out, and Varun cannot be situations, in a sense, portrayed as accusers here, my lordships. And in this particular case also, with the mere presence of Varun at the crime scene, he has been portrayed as a co-accused here, my lordships. So, but we have to implement the principle of Dori Incapax here, my lordships. Since the principle of Dori Incapax suits for the person below the age of 14 years, my lordships. But in the case of Gopinath Ghosh versus State of West Bengal, the High Court of Calcutta held that the juvenile's age and mental state should be taken into consideration in setting up the criminal liability here, my lordships. And in this particular case also, there needed to be an identification of the mental state and the age of the particular person who has been mentioned here, my lordships. So, we have to implement the dowry income tax, and in this case also the principle of dowry income tax has been incorporated for a person whose age was 17, my lordships. So by applying this principle, we have to take consideration about the mental state of the Varun here, my lordships. In this particular case, the mental state of Varun was in a panic manner, my lordships, because he was unaware of the fact that the Varun is going to snap the chain of the particular person here, my lordships. And the statement made by Mr. who was the husband of Marina, states that her wife saw the person who was driving the vehicle without a mask, my lordships. So it clearly states that the person is not wearing a mask, my lordships, and he was just called for a ride by Tarun, my lordships, and he was gone for a ride there. So he was unaware of the fact that Tarun is going to snatch the chain of the particular lady, my lordships. So and the vehicle which went near to the marina, Varun was triggered with Tarun, which has been clearly mentioned in the statement made by Varun before the magistrate. So it is clear that there is no common intention, and the common intention is required for setting up the constructive or joint liability, which has been incorporated under the section 34 of the IPC. In this particular case of Bura vs. State of Madhya Pradesh, it clearly explained that there should be a meeting up of minds.
Counsel, your argument has 4 compartments based on what you have discussed. Whether you are going to say there is no link between Tarun and Varun, or the capacity or mindset is not established, or the crime, whether you are going to make your fact.
In this particular case, my lordships, Tarun has no common intention, or there is no sharing of intention between Varun and Tarun, my lordships. Varun is associated with Tarun, my lordships, and his presence is also at the crime scene, my lordships.
Which section of Indian Penal Code says
Section 34. Acts done by several persons in furtherance of common intention. When a criminal act is done by several persons in furtherance of the common intention of all, each of such persons is liable for that act in the same manner as if it were done by him alone. In this particular case, my lordships, there is no common intention, or there is no pre-planning, or there is no meeting of minds between Varun and Tarun, my lordships. Since because here the act has been done by Tarun, and it has been agreed by Varun, my lordships, and he has made a statement that he was driving the vehicle there. But there is no fact that Varun is also intended to snatch the chain, my lordships. So it is clear that there is no common intention shared between Varun and Tarun, my lordships, in this particular case. So he cannot be made liable, my lordships. Lordships.
Can we not have any intention? What prevented Varun to give the complaint as against Tarun?
Let me add to my brother judge. When police to describe all event whatever reported in the FIR.
Much obliged, my lordships. In this particular case, Varun is a juvenile, my lordships, and he at the particular crime scene.
Both are crimes.
Indeed, no, my lordships. Varun is not a juvenile here, my lordships. Varun is a juvenile, my lordships.
One more question. You have stated in the panic situation, Varun was driven the vehicle after snatching. Who has not stopped the vehicle?
Much obliged, my lordships. He stated before the magistrate that due to the fear of the mob attack, he didn't stop the vehicle and sped up, my lordships. So he was afraid of the mob. Varun is afraid that if anything committed by Varun, like Tarun, will also be made liable on Varun here, my lordships. So he was afraid of that particular incident.
Fantastic. So there is a line which clearly says, then which prevent him not to approach the police. Is there any criminal administration prevents minor shouldn't be a complainant?
Indeed, no, my lordships.
Then
Lordships, in this particular case, he made confirmation that the chain was saved with that particular lady, and she was not after the
leave alone the compromise. Please refer any substantial law which says minors are ineligible to approach the police station to lodge a complaint.
Indeed, no, my lordships. They are also.
Then please establish the statement what our brother judge clarified, which made him to stop or slow the vehicle after hearing a particular lady called Marina.
Much obliged, my lordships. He didn't stop the vehicle because of the afraid and panicness of the mob attack, my lordships. And he did not make a complaint to the police or his parents, since because he confirmed with the Tarun that the lady was saved with her chain and she was not got injured, my lordships. He knows the fact that she got injured after the police
So
approached him, my lordship.
can't we establish an abatement after identifying okay chain is safe? Then he is not ready to go and approach.
Indeed, no, my lordship, since because the abatement cannot be invoked here, my lordships.
Chain has not been snatched.
Indeed, yes, my lordships. By referring to the section 379 of IPC, moving out of the property amounts to theft, my lordship. If the possession is transferred or not, it amounts to theft, my lordships. So, the moving out of property with the criminal intent amounts to theft, my lordships. And the offence is made out by Tarun alone here, my lordships. Varun cannot be invoked under the section 379 here, my lordships. Because there is an absence of common intention and pre-planning or beating up of minds here, my lordship. So he cannot be made liable under section 379 here, my lordships.
Could you read paragraph number 7 of the compromise and substantial part by Brother Judge clarified? The third line from the fourth line from the top.
Yes, my lordships.
Marina immediately reacted
And he snatches and the one who sat in
Last line of the same page, same paragraph.
Yes, my lordship. Marina was severely injured on her neck and her hand due to which could not speak and was admitted to the hospital, my lordships. Much obliged, my lordships. This act of Tarun made, which was made here, clearly invokes the provision of 397 here, my lordships. And the 397 of the Indian Penal Code has a greater interpretation which has been made in the case of Kulkumar versus Delhi administration, my lordships. In this particular case, it has been clearly stated that the terms which refers.
Please substantiate 79, then you move it 97. Okay?
Much obliged, my lordships.
So whether the section whichever made out in the FIR, is it right, or would you like to make any difference by saying Varun itself not concerned with the offence whatever reported in the complaint? Then you can jump with 397.
Much obliged, my lordships. 379 is made out here, my lordships. But there is no criminal liability on Varun here, my lordships. Since because Varun is not actively participating in this particular case, my lordships. Since because in the state of Rajasthan versus Rajendra Singh, it clearly stated that the mere presence in the crime scene is not sufficient to prove the guilt of the particular person here, my lordships. There needed to be an active participation. Here, there is a lack of active participation here, my lordships. Since because he is present and he is driving the vehicle, does not constitute the guilt of the offence, my lordships, and he should be presumed as an innocent until his guilt is proven, my lordships. So
he did not stop the vehicle.
that's why, my lordships, he spotted the vehicle since because of the mob attack, my lordships. Since it was a common road for the public, there were several public persons in that particular road, my lordships. If he stopped the vehicle, the public, without knowing the fact that he was unaware of the chain snatching, would attack him, my lordships. So due to the fear of the mob attack, he didn't stop the vehicle here, my lordships.
Right, contradicting what is the last line you made in the page number 7 of the complaint? She was tracked.
Indeed, yes, my lordships.
By Tarun alone, without Varun's speeding up of the vehicle.
Much obliged, my lordships. Tarun has yankled the chain by sitting on the brilliant seat, my lordships. Varun has also made the statement that he don't know what to do and he didn't know what is happening behind him, my lordships. He was unaware about what is happening behind him, my lordship. So he has no intention to cause any harm or to cause the chain snatching, my lordships. So it cannot be made a criminal liability on Varun here, my lordships. Moving to the section 397, my lordships. In this particular section of 397, there is a greater interpretation made in the case of Kulkumar versus Delhi administration, my lordships. The case highlights the words the offender and such offender of the particular case, my lordships. Particular section, my lordships. The term the offender and such offender mentions the particular offender here, my lordship. And in this particular case, the particular offender is Tarun, who yanked the chain and dragged her out of the street, my lordship. So the criminal liability should be made on Tarun alone, my lordship, and there is no constructive liability should be imposed for the persons who are there, my lordship. And it has been upheld by perpetrates to the person who is the particular offender committing the particular crime, my lordship. So section 397 cannot be invoked for Varun here, my lordship, and it should offense has occurred and Mrs. Kashiram Kunte beyond a reasonable doubt here, my lordship. In this particular case, the CCTV footage has been taken here, my lordship. The CCTV footage has taken on the date of occurrence on 8 August 2023, my lordship. But the police has arrested Varun on 17 August 2023, my lordship. on 23rd August 2023, my lordship, which clearly states that the CCTV footage is not clear, my lordship. Since because if the CCTV footage is clear, then they would have arrested the particular person at the time of occurrence of the crime, my lordship.
Not necessary, but warrant having 164 statement before concerned magistrate.
Lordships,
Warrant already gave 164 statement before concerned magistrate.
indeed no, my lordships. After the arrest on 23rd August, he made the statement, my lordships. But the offense of the
It's an 164 statement before concerned magistrate is enough.
lordships, if there is no direct evidence or there is no corroborative evidence, this such kind of cases can be taken into consideration under the section 313 of CRPC, my lordships. Any statement made before the magistrate can be taken for or against of the accused, my lordships. In this particular case, we should rely on this particular statement since because there is no direct or corroborative evidence, my lordships. So this statement shall be taken into consideration, my lordships. Lordships,
Admitted fact need not be proved.
it is, my lordship. But in this particular case, in the absence of direct evidence, we need to take into consideration about these statements made by Varun, my lordship. And since because the trial has not been started here, the FIR alone is made out here, my lordship. The charge sheet has not been filed yet. In this particular case, Varun should be treated as a juvenile, my lordship. This is because his age is 17. He should be treated as a juvenile, but he was treated as an adult and he has been tried before the criminal court, my lordship. The proceedings at much of this is, my lordship, but the preliminary assessment should be made by the juvenile justice board alone, my lordship. Since because this person is arrested and
You are going to say 390. Are he
indeed no has been
this code?
much of this, my lordship. Here there is no criminal intention, but here there is.
Whether he is an accused, because when you are not going to say he is an accused, then you have no need to prove anything on.
Much of this, my lordship, the accusation has been made on Varun here, my lordship.
Okay,
But
so then there is a choice for the police to file an FIR against.
indeed yes, my
But he
lordship.
should not be tried under the criminal administration. He
Indeed
should be
yes, my
tried
lordship.
under,
Indeed yes,
right?
my lordships.
So now you want to be tried under the criminal justice or juvenile justice code.
Indeed yes, my lordship. Since because the FIR
FIR need not be washed.
indeed no, my lordships, the FIR filed
Okay.
was
So this is in addition to what my brother just clarified. So please open the appendix, some 15th line from the bottom. Varun himself admitted, I simply beat up the motorcycle and there was nothing in my hand beyond that. He himself explained that he was in urgent need of money so that he was trying to get the child.
indeed yes, my lordships. This
This
case,
said, admitted facts need not be proved.
lordships, in this particular case, Tarun has made that statement to Varun here, my lordships. Tarun was in the need of
This is a statement given by Varun to the magistrate.
indeed yes, my lordships. Much of this, my lordships. In this particular case, my lordships, Varun should be treated as a juvenile, my lordships. Since the accusation is made against him, but he cannot be convicted under these sections since because he has no criminal intention or he has no active participation. He is just a mere present in the crime scene, my lordship. Mere presence does not amount to prove the guilt of the offense.
Is there any precedent which says non-fulfillment of criminal element should not be tried under code of criminal procedure?
Much of it, my lordship, we should take consideration about the juvenile procedures here, my lordship, since because
Which section of Juvenile Justice Act says? Please open and read and elaborate to us.
much of it, my lordship. In the juvenile justice code and the Tamil Nadu state rules, my lordship, in the state rules, it clearly states.
Whether commonly says whether the same order in Tamil Nadu or in California.
Indeed, yes, my lordship. It is parametric to state of Maharashtra, my lordships. And the criminal rules has been submitted before this court, my lordships. Much of which, my lordships, in this particular case, in this particular rules, page number 6, point number 2 from the last, my lordships. Page number 6, point number 2 from the last, it clearly states that in case of heinous offences for a child below the age of 16 years, as on the date of commission of an offence, shall be disposed by the board, and for the child above the age of 16 years, as on the date of commission of an offence, the board shall conduct the preliminary assessment as per the section 15 of the Act, my lordship. So, even if a person is committing an heinous offence, even if he is having an intention and even he committing a heinous offence, he should be preliminarily assessed by the board here, my lordship, and his age and the mental capacity should be taken into consideration and it should be determined by the board alone, my lordships. There is no authority for the criminal court to take a preliminary assessment here, my lordships. And even if the preliminary assessment is taken by the court, it should transfer the case to the juvenile justice board here, my lordships, which is stated under the juvenile procedure, my lordships. In this particular procedure, it clearly states that if in the case juvenility has been ascertained by the criminal court before the trial has commenced, the criminal case should be transferred and the board is instructed to file the charge sheet before the juvenile justice board, my lordships. And if the trial has commenced before the criminal court to prevent the delay, the court may continue with the trial and record a finding of guilt or otherwise. And if the juvenile is found have to be committed the offence, my lordship. But in the case to ascertain the juvenility here, the juvenile justice has the authority to ascertain or determine the juvenility here, my lordship. Since because even though the court has the power to conduct the trial until the stage of the sentencing, my lordships, but the certainty of the age and the mental nature should be made by the juvenile justice body, my lordships. And here the police has not followed the legal proceedings, my lordships, which will be dealt by some in the second issue, my lordships. Much of it, my lordships. Now, I would like to move on to the Zena's rape and murder case here, my lordships. Much of it, my lordships. In the Zena's rape and murder case, there is no direct evidence has been found in here, my lordships, since because there is only a single evidence that the Varun's motorcycle was present 1 kilometer away from the crime scene of occurrence, my lordship. In this particular motorcycle is also has a tampered number plate here, my lordship. The accused person made out here is Tarun, my lordship. The Tarun has been made as an accused, my lordship, but the Varun has also been taken into consideration in this particular case, since because his vehicle was the major evidence of this particular case, my lordship. But in the state of Maharashtra vs. Kashinath Kunte, it clearly states about the corpus delicti rule, my lordship. In this particular corpus delicti rule, the action of the accused should have a causal link between the accused and the harm suffered by the victim here, my lordship. Here, there is no causal link between Varun and Zena here, my lordship. And Varun has also made a statement that Varun is going to meet his transgender fiancé, so he borrowed his vehicle here, my lordship. And the Zena's father, Paramo, has also made a statement that she went out for meeting his friend here, my lordship. So, she has went out for meeting his friend, and Tarun was also saying that he was going to meet his transgender fiancé, my lordship. So, there is a causal link between Tarun and Zena here, my lordship. But there is an absence of causal link between Varun and Zena in this particular case, my lordship. So, Varun cannot be invoked in the FIR which has been made for Tarun here, my lordships.
Arun ride the bike on his own motion or request made by Tarun or not?
Lordships, in the case of Zena's rape and murder, Varun was not riding the bike, my lordships. He just borrowed the vehicle, my lordships. But in the case of chain snatching, Varun rode the bike, my lordships, on the request of Tarun here, and he was triggered by Tarun, my lordships. Since because the fact itself clearly states that the paragraph number 4, it clearly states that the threat of involvement of juveniles in chain snatching is increased in Malta, and in the paragraph number 3, it clearly states that due to their innocent and easily influenced nature, they can be manipulated at a low cost, my lordship. In this particular case also,
as you said earlier, Varun has no common intention to ride the bike and commit the offence.
indeed, no, my lordship. I stated that he has no common intention to snatch the chain, but he was driving the vehicle, my lordships.
It is not a case of prosecution that in Tarun case, Varun is arrayed as accused.
Indeed, yes, my lordships. Varun is not included as an accused here, my lordships. But the witness statement has been taken from Varun here, my lordships, and
Not an issue.
much of it, my lordship. But there is a chance for including Varun in this particular affair, my lordships, because in the absence of
Even cover, it is not the issue.
indeed, yes, my lordships, but there is other reasonable doubts which could be aroused here, my lordships, because Varun's vehicle is present there, and if the loss of credibility has been made on the statement made by Varun, he could be held liable in this particular case, my lordship. So, in order to prevent that, this statement has been made by the petitioner counsel here, my lordships, in the Zena's rape and murder case. And the particular case question asked by the ride with the Tarun, my lordships, and Tarun has treated here, my lordship. Tarun has manipulated Varun because Varun has fed up with his lifestyle, my lordship. So he was already in a frustrated state that he was he was not sufficient to meet with the daily needs of that particular person, my lordship. So he got manipulated by Varun here, my lordship. So that's why he cannot be made liable here, my lordship, since because there is no common intention. Much obliged, my lordships. Lordship, the lordships are satisfied with the advance arguments of first issue. The council is permission to proceed with the second issue.
This is in connection with what you have responded to my sister judge.
Much obliged.
Please go to paragraph number 15. We read fifth line from the bottom.
It is.
He himself admitted, Tarun asked my motorcycle to meet her transgender fiancé.
It is, my lordship.
I gave my motorcycle, but he chopped it in a forest area. How did he knew? We don't know. And of burnt body, I don't know why he did it so.
It is, my lordships.
Then last line, I was explained the same to the Karavadu police also.
It is, my lordships.
So is it not a proof to take a cognizance by the police against Tarun as if Tarun burned her own fiancé?
Much obliged, my lordships. This statement was taken from Varun before the statement taken before the magistrate on this
It has a two compartment. He himself admitted I disclosed the same to the Karavadu police station. That was the first. Second, he himself admitted. Why you are making a confusion to the bench? It was before and after.
Much obliged, my lordships. In this particular statement, he also made a statement that before the Karavadu police that I am very afraid that he purposefully did that to trap me into the issue, my lordship. So, in order to exclude him from the suspicion, we have made the statement, my lordship. Because before the Karavadu police, he made a statement, and that statement in the last third para, I am very afraid that he purposely did that to trap me into the issue. I am innocent. I am ready to come wherever to witness this, my lordship. This impliedly says that he has no
I don't know why he did.
much obliged, my lordships, but he was unaware. He was unaware of the incident, my lordship.
That's what fact says. He aware the fact he burned his own fiancé.
Indeed, no, my lordships. The line.
That's what I asked him to read. Tarun asked my motorcycle, I don't know why he did it so. Please explain what is the same line with 7 words.
Much obliged, my lordships. Tarun has lent his motorcycle, my lordships, and the statement made by Varun clearly says that he dropped it in a forest near the half-burned body, my lordships. He didn't ascertain that he burned the particular body, my lordships, and he.
When Tarun knew the body is burned by example,
Lordships.
who went informed to Varun, there is a body where it is burned.
Much obliged, my lordships.
Tarun happily collected Varun's cycle and right and dropped and left.
Indeed, yes, my lordships. He has been informed with the Karavadu police, my lordships. Since because the Karavadu. Indeed, yes, my lordships.
Where it says so?
Lordships, in the paragraph number 12, it clearly states that tracing the motorcycle, Karavadu police caught Varun and inquired him, my lordships. During the interrogation, he revealed the following information, my lordships. So, the Varun was identified as a party in the Zena's rape and murder case at first, my lordships. And then only he got connected by the armed police in the chain snatching case, my lordships.
So after seeing Varun's mind, the Karavadu police actually took him and asked that Varun made a statement, I don't know why he did so.
Indeed, yes, my lordships. He was unaware of the incident which has occurred to Zena here, my lordships.
He is unaware means he is not ready to disclose the fact.
Indeed, no, my lordships. He just gave the bike to Tarun here, my lordships.
Still the 2 lines fine. He gave bike what Tarun asked to meet her own fiancé.
Indeed, yes, my lordships.
Next line says, I don't know why he did so.
Much obliged, my lordships. The statement, I don't know why he did.
You don't know what Varun didn't know.
That's only my lordship. He didn't know about what is Tarun is going to do, my lordship, just because Tarun helped him in several ways, my lordship. So he was grateful to Tarun here, my lordship, and he. Indeed, yes, my lordships. He was grateful to Tarun, my lordships, and helped him in whatever way he asked, my lordships. But this does not amount to prove that he was in the place of occurrence or he was aiding or abetting the offense committed by Tarun, my lordships.
So taking an advantage of juvenile, Tarun had to use Varun.
Indeed, no, my lordships. Indeed, no, my lordships. It cannot be taken. It cannot be taken that way, my lordships. Since we
So what is your conclusion?
lordships, I would like to conclude that Varun cannot be made liable for the chain snatching case, my lordships, and there should be no inclusion of Varun in the affair of Zena's rape and murder case, my lordships. That's what the petitioner tries to conclude, my lordships.
Now, one of the cases, about
3 days, my lordships.
even after your prosecution is done.
3 days, my lordships.
So, what do you say about cancellation?
Lordships, it will be dealt with co-counsel in the issue number 3, my lordships. The council would like to move on to the issue number 2, my lordships. Much of the lordships. The issue number 2 is whether the legal proceedings in the chain snatching case is complied with the criminal justice system. In this particular case, the criminal justice system has not been complied here, my lordships, since because Varun is a juvenile here, my lordships. He should be treated as a juvenile and the proceedings should be made according to the procedure established by law, my lordships. And the person is being arrested here, my lordships. Section 10 of the Juvenile Justice Act says that no person should be detained in the jail, my lordships. Even if he got apprehended or detained by the police, he should be granted a bail under Section 12 of the Juvenile Justice Act, my lordships. But in this particular case, the bail has been granted at first, but due to the insertion of 302, that is the murder which has been committed by Tarun, Varun has been cancelled with the bail which has been granted to him, my lordships. Since because here in this particular case, the bail has been made out based on the presumption of innocence until all the bails will be made based on that principle, my lordships. But in this particular case, the section 15 of the Juvenile Justice Act says that for a child above the age of 16 years, as per the date of the commission of the offence, the board shall conduct the preliminary assessment, my lordships. Here, the preliminary assessment is not made out by the board, is not made out by the Juvenile Justice Board, and it is not initiated by the police here, my lordships. Since because he was arrested and he was produced before the magistrate, but the procedure to remand a juvenile is should be followed here, my lordships. But it has not been followed by the police here, my lordships. Since because he was a juvenile and he himself ascertained that he was a juvenile, my lordships. And the court has also ascertained him as a juvenile and granted the bail under Section 12 of the Juvenile Justice Board, my lordships. But the cancellation of bail should not be made, my lordships, since because according to the Tamil Nadu government gazette, which has been published by Tamil Nadu government, it clearly states that in case of heinous offences alleged to have been committed by a child who has completed the age of 16 years, the child welfare police officer shall produce the statement of witnesses recorded by him and other documents prepared during the course of investigation within a period of 1 month from the date of first production of the child before the board. So, all the statements which have been taken from the Varun should be produced before the Juvenile Justice Board, my lordship. But it has not been complied here. Hence, the criminal justice system is not being complied here in this particular issue, my lordships. And by looking towards the Tamil Nadu's children policy, it also ascertains about the juvenile justice, my lordships. In this particular article, the article 40 says that children who are alleged to have committed a crime or breaking the law are entitled to receive legal help and a fair trial, which takes into consideration their age and situation, my lordship. Here, the police has failed to take consideration about the situation and the mental capacity of Varun here, my lordship. Since because the situation alone portrays him as an accused and the mere presence of his occurrence in the crime scene does not constitute that he was an offender in this particular case, my lordship. So, it cannot be made liable that Varun is making of the offence, and based on that, the bail should not be cancelled here, my lordship, and the proceedings should not be initiated before the criminal court, my lordship. Even though it was a heinous offence, he should be taken a preliminary assessment before the Juvenile Justice Board alone, my lordships, and after the receipt of that Juvenile Justice Board under the section 19 class 1 of that particular case, he should be made out before the children's court alone, my lordship. It should not be tried in the criminal court. It should be tried before the children's court, my lordship, which has been clearly mentioned in the section 19 subclass 1 of the Juvenile Justice Act, my lordship. So, it is clear that the criminal justice system has not been complied with the legal proceedings which has been taken or carried out in this particular case, my lordship. And I would like to add up the Zena's rape and murder case with the criminal justice system in this particular case, my lordship, since because the investigation officer, who is Veeradurai, has included the section 377 and 302 of IPC in this particular case, my lordship. In this particular case, the provision which has been involved by Veeradurai is legally correct, my lordship, since because the 377 deals with the unnatural offences which has been made here, my lordship, and the person who was a transgender here in this particular case is not to be considered as a woman here, my lordship, since because the article, the section 2 subclass K of the Transgender Rights Act of 2019 clearly states that the person who is identified as a transgender should be treated as a third gender alone. Whether he has undergone a 6 years surgery or not, he should not be treated as a male or a female here, my lordship. So, section 376 cannot be invoked in this particular case, my lordship, since it falls only for the women here, my lordship, and section 377 deals with the unnatural offences, my lordship. Since this person, Zena, was a transgender here, she lacks a female genitalia here, my lordship. So, if there is a lack of female genitalia, the offence of rape will be committed by the carnal offence, my lordship. So, it invokes the 377 of the Indian Penal Code alone, my lordship. So, the accusation and the charges framed under the FIR of Zena's rape and murder case is legally valid, and the investigation officer should not be made liable that he was not investigating the case properly in this particular case, my lordship.
Whether the bail was cancelled by court itself or any application made by victim family.
Lordship, instead the bail has been granted based on the Varun's application, my lordship, and the bail has been cancelled due to the insertion of 302 of IPC, my lordship.
One more doubt. So, investigating officer has not registered the case on the date of receiving the complaint itself.
Much of it, my lordship, it will be dealt by court the issue number 4 in detail, my lordship. Much of it, my lordship.
Also, final clarification.
Yes,
So, your researcher has submitted this paper.
Yes,
So, whether policy is in the law,
much of it, my lordship, policy is not a law, my lordship, but
how it would bind the constitutional bench?
much of it, my lordship, but it should be taken into consideration, my lordship. It is
Can it say so any authority to support policy can be considered by the constitutional bench?
much of it, my lordship, in this particular Tamil Nadu children policy has been made out based on the United Nations Conventions of Rights of the Children, which has been published signed by India on November 20, 1989, my lordship. And based on that, the separate rules have been made for Tamil Nadu, my lordship.
Conventions are considered as a law.
Indeed, no, my lordship, but
The conventions also not a law, policy also not a law. How you are expecting constitutional bench to accept?
lordship, we have to take considerations about the conventions here, my lordship, because in the case of under Article 50 of the Constitution says that there should be a respect shown before the shown for the International Convention, my lordship, and in the case of
What constitutional bench understand 50 separation of executive from judiciary?
lordship, Article 51, my lordship. And in the case of Vishaka case, it has been clearly stated that the international conventions which are not violative of the fundamental rights should be taken into consideration and can be implemented in a state or a country, my lordship. And based on the international convention alone, this Tamil Nadu state policy has been made, and it should be followed, my lordship.
No.
Much of it, my lordship, with the lordship is satisfied with the advance arguments of first and second issue, the council like to call upon the government, my lordship.
Thank you.
Much of it, my lordship.
Your Lordship, the council is permission to approach the lands. Much of it, Your Lordship. Your Lordship, this is the council number 2 appearing on behalf of the petitioners, Your Lordship. Your Lordship, the council is functioned to collectively address the benches, Your Lordship. Much obeyed, Your Lordship. Your Lordship, the issue says that whether the cancellation of bail violated any rights of the offender and whether the arrest warrant issued to the investigation officer is Your Lordship, this particular FIR has been not filed at the date. Your Lordship, the complaint made by the petitioners is on a missing child case, Your Lordship.
Just by citing Independence Day, taking the complaint is sustainable.
Your Lordship, not only by citing the Independence Day, Your Lordship, a missing person case is a non-cognizable offence, Your Lordship. And further, Your Lordship, non-cognizable offence when it is reported to police, it is generally made a note in the general diary of the station, Your Lordship. Only after the preliminary inquiry has been done, the FIR has been registered, Your Lordship. So the police officer has made reasonable, required reasonable time to register an FIR, Your Lordship.
Is the case coming under non-cognizable offence?
Indeed, yes, Your Lordship. Your Lordship.
How?
Indeed, yes.
Referring to the sections of the law, whichever you want to say.
Your Lordship, as per the Tamil Nadu Police Standing Orders, it clearly states that when a missing person child has been informed, it is to register under the general diary of the police station, Your Lordship. And further, it is also mentioned as a non-cognizable offence, Your Lordship. Much obliged, Your Lordship. Shall I say the maintainability of the petition filed, Your Lordship? Much obliged, Your Lordship. Your Lordship, it is humbly submitted that the petition filed under 482 of CRPC solely maintainable, Your Lordship. Your Lordship, section 482 of CRPC states that a petition can be filed for three purposes, Your Lordship, which is to make orders necessary to give effect to any order under the code and to prevent abuse of the powers and to secure the ends of the justice, Your Lordship. Your Lordship, both the petitions, I would like to separate the petition, Your Lordship. First petition is filed on behalf of the Varun, Your Lordship, on cancelling of the bail, challenging the legal proceeding, Your Lordship. Second petition filed is behalf of the Veerajay, who is the investigation officer who has been issued an arrest warrant by the magistrate court, Your Lordship. To challenge the issue arrest warrant, the petition has been filed, Your Lordship. In both the cases, there is Your Lordship, there is a abuse of power here, Your Lordship. Your Lordship, as per the statute state of Karnataka versus M. Devendra, it clearly states that inherent power to squash a complaint, initiated procedure is warranted only in situation when the complaint is absurd, aggravating or unjust, or fail to reveal any offence, Your Lordship. Your Lordship, the cancellation of bail does not amount to reveal any of the offences committed, Your Lordship. Further, Your Lordship, by stating the case R.K. Kapoor versus State of Punjab, the court considered in cases where there is no legal evidence or evidences that is inconsistent with the accusation, the High Court will not investigate on the reliability, Your Lordship. Your Lordship, and it cannot cancel a bail, Your Lordship. But Your Lordship, by this particular statute, it is very clear that there is no evidence, Your Lordship. The cancellation of bail is not based on any of the evidences which has been established before the court, Your Lordship. Hence, the cancellation is not valid, Your Lordship. Your Lordship, further, Your Lordship, in case of arrest warrant, there is no clear provision or there is no clear evidence that the proceeding has been violated, Your Lordship. The procedure which has been followed is as per the law established by the state government, Your Lordship. So, Your Lordship, the petition filed under 482 is maintainable, Your Lordship. Your Lordship, the council seeks permission to move on to the advanced argument of issue number 3, Your Lordship. Much obliged, Your Lordship. Your Lordship, issue number 3 is whether the cancellation of bail violating any rights of the offender, Your Lordship. Your Lordship, it is humbly submitted that the cancellation of bail violates the rights of the offender, Your Lordship. Your Lordship, the bail is granted under section 12 of the Penal Justice Act, Your Lordship. Your Lordship, section 12 of the Juvenile Justice Act states that when a juvenile offender commits a bailable or non-bailable offence, he must be issued a bail either by a surety or bond, either in the presence of a surety or not in the presence of the surety, Your Lordship. Your Lordship, in this particular case also, Varun is a juvenile. He has been granted a bail, Your Lordship. His bail has been cancelled only after the insertion of 302, Your Lordship. Your Lordship, as stated by my co-counsel, Varun has not been actively participated in the offences mentioned in the FIR, Your Lordship. Hence, Your Lordship, cancellation of bail is violating the rights of the offender, Your Lordship. Your Lordship, as per the Tamil Nadu state policy, it clearly states under Article 14, a juvenile entitled to receive a legal help here, Your Lordship. Your Lordship, bail is also interpreted as a legal help here, Your Lordship. He must be entitled to receive a legal help here, Your Lordship. Cancelling of bail is amounting to breaching this legal help here, Your Lordship. Further, Your Lordship, for cancellation of bail, Your Lordship, there is a triple test to be followed in granting a bail and cancellation of bail here, Your Lordship. Your Lordship, this triple test says that there must be three categories that must be fulfilled and established. First one is the flying risk. Second one is the tampering of evidences. Third one is contact with the accused, Your Lordship. Your Lordship, none of these grounds have been proved and established in front of the court by cancelling the bail here, Your Lordship. Your Lordship, this particular triple test must be conducted before cancelling of a bail, which has been stated in the case of Preeti Chandra's Directorate of Enforcement case, Your Lordship. Further, Your Lordship, the bail granted here is an interlocutory order here, Your Lordship. Your Lordship, when the court does not, High Court cannot exercise its inherent power in the divisional jurisdiction of an interlocutory order here, Your Lordship. Your Lordship, as per the case of C. Your Lordship,
Involving 482, not a revisional jurisdiction. Not 397 has been used.
Your Lordship,
482 has been used.
granting of a bail is an interlocutory order which has been made in an interim stage of a case here, Your Lordship.
482 automatically will come into the picture.
Your Lordship, 397 subclass 2 clearly states
397 says, only as against final order, 397 would like. As against interlocutory order, only 482 alone would like.
Your Lordship, bail granted here is an interlocutory order here, Your Lordship. I would like to state the provision here, Your Lordship.
Section 397 here.
Indeed, yes, Your Lordship.
As against final order, revision would like.
Your Lordship, the 397 subclass 2 clearly states that the powers of revision conferred by subsection 1 shall not be exercised in relation to any interlocutory order passed in any appeal, inquiry, trial or other proceedings here, Your Lordship.
So it means
Your Lordship, this the cancellation of bail is not valid here, Your Lordship. Hence, Your Lordship, 482 has been exercised here to prevent the abuse of the power here, Your Lordship. Your Lordship, this
So
particular...
according to council, 482 has the limitations to 397 of CRPC.
Your Lordship, indeed, yes, Your Lordship.
Then why you read the 482 marginal note in the setting of
Yes, yes,
CRPC?
you need to say cancellation of bail is interlocutory order or final order.
Your Lordship, it is a granting of bail is an interlocutory order here, Your Lordship. The cancellation is done by the magistrate court here, Your Lordship. Your Lordship, this is an abuse of the power here, Your Lordship. Hence, 482 can be put here, Your Lordship.
Straight proceed. Action is straight proceed. The cancellation of bail amounting to interlocutory order or final order.
Interlocutory order, Your Lordship.
In case if you say it is interlocutory order, that 482 alone will be applicable.
Indeed, yes, Your Lordship. Sorry, apologies, Your Lordship. Much obliged, Your Lordship. Your Lordship, in the authority of Purin vs. Ramla, the court clearly said that it is to be kept in mind that the concept of setting aside that unjustified, illegal or coercive order is totally different from the concept of cancelling a bail on the ground that accused has misconducted himself or because of some new fact requiring such cancelling, Your Lordship. Your Lordship, it is clearly argued by the co-counsel that the Varun is not actively participated in the offences mentioned in the FIR, Your Lordship. And further, Your Lordship, insertion
No, you are simply retaining him. He did not say he is not actively participated. What was statement made by your co-counsel?
Your Lordship, he cannot be made liable for the offences here, Your
For
Lordship.
what?
Your Lordship, he does not have the
Phrase.
common intention here, Your
Ah.
Lordship. Your Lordship, when
But
there is no
how you will
common...
distinguish common reason and active participation in the crime?
Your Lordship, only in the presence of common intention, he can be actively participated here, Your Lordship. If there is no common intention, there is no active participation here, Your Lordship. Only a mere presence has been made in this particular offence mentioned in the FIR here, Your Lordship. Much obliged, Your
One
Lordship.
more question.
Yes,
He
yes.
had an intention to obtain a legal driving license.
Indeed, yes, Your Lordship.
But as far as this, you say that he had no intention.
Your Lordship, in this particular, for this question, I would like to state that theory here, Your Lordship, which is Felson's rational choice theory, Your Lordship. It clearly states that Felson pointed out that the individuals vary greatly in their behavior from one situation to another, and that criminality might flow from temptation, bad company, idleness, or provocation here, Your Lordship. Your Lordship, Tarun is the person who has been committed all the offences here, Your Lordship. Only by his provocation and his bad company, Varun has been got his license here, Your Lordship. But he is not mere fraud by the getting of the license at the age of 17 cannot amount to say that that particular person has been committing such a grievous offences mentioned in the FPR here, Your Lordship. Further, Your Lordship, by stating another theory which is Hilscher's control theory, it clearly states, Your Lordship, Sutherland's differential association theory here, Your Lordship. Your Lordship, criminality is a process of differential association with others who communicate criminal values and who advocate the communications of crimes here, Your Lordship. Your Lordship, in this particular case also, Tarun has been advocated his incident here, advocated his crime to Varun here, Your Lordship. Based on this advocacy only, he has been, Varun has believed that he has not snatched the chain and there was no any offense committed here, Your Lordship. And Your Lordship, this is, it is very clearly stating that Varun is not being actively participated here, Your Lordship. And by cancelling the bail for insertion of 302 is amount violation of the rights of the offender here, Your Lordship. Much obliged, Your Lordship. Your Lordship, by considering the right of the offender here, Your Lordship, the primary right is the presumption of innocence here, Your Lordship. Your Lordship, as per the section 3 of Penal Justice Act, which states the general principles to be followed in the administration of this act here, Your Lordship. Your Lordship, under subclass 1, it clearly states the principle of presumption of innocence, Your Lordship, which states any child shall be presumed to be an innocent of any malafide or criminal intent up to the age of 18 years, Your Lordship. Your Lordship, in this particular case, the cancellation of bail violates this presumption of innocence here, Your Lordship. There is no clear evidence to substantiate his common intention and active participation in the offences mentioned in the FPR here, Your Lordship. Hence, this amounts to violation of the principle of presumption of innocence here, Your Lordship. Further, Your Lordship, in the case of X versus State of UP, it clearly states that the general principles as enumerated in section 3 of the Penal Justice Act must be kept in the mind as guiding factor here, Your Lordship. Your Lordship, the court has been failing to follow the principle of presumption of innocence in cancelling the bail of Varun here, Your Lordship, who is a juvenile here, Your Lordship. Further, Your Lordship, this particular presumption of innocence is also guaranteed by the Universal Declaration of Human Rights under Article 11 here, Your Lordship. It clearly states that everyone charged with a penal offence has the right to be presumed innocent until proven guilty according to the law in a public trial at which he has had all the guarantees necessary for his defense here, Your Lordship. Your Lordship, in this particular case also, the cancellation of bail on insertion of 302 cannot be made here, Your Lordship, as there is no clear evidences here, Your Lordship. Direct evidences to rely on here, Your Lordship. Further, Your Lordship, by considering the arbitration.
Whether UDHR will bind the Constitutional Court?
Your
Is
Lordship,
it a law?
indeed no, Your Lordship.
Then?
Your Lordship, it is a universal human right here, Your Lordship. It must be
Universal
considered.
Declaration of Human Rights. Is it a law? Will it bind the court?
Your Lordship, it must be considered here, Your Lordship.
But it's not law.
Much obliged, Your Lordship. Your Lordship, by considering the arbitrary detention here, Your Lordship. Your Lordship, Varun has been arrested on 23rd August 2023 here, Your Lordship. He has been produced in the court on 25th August 2023 here, Your Lordship. One day he has been undergone a detention here, Your Lordship. Juvenile cannot be undergone any kind of detention here, Your Lordship. In case, much obliged, Your Lordship, for the question which you have been raised earlier on the Universal Declaration of Human Rights, it should be taken into consideration, Your Lordship. UDHR also complies with the fundamental rights here, Your Lordship, which is already stated by the Council by the statute. Vishaka case is clearly stated that it can be complied here, Your Lordship. Your Lordship, it is to be considered here, Your Lordship, as per the authority already cited by Vishaka case, it can be considered by the Constitutional Bench here, Your Lordship.
What's your answer for investigating officer not registering the case legally?
Indeed, yes, Your Lordship. Shall I move on to the fourth issue by answering this question, Your Lordship? Not obvious, Your Lordship. Your Lordship, in this particular, the fourth issue is whether the arrest warrant issued to the investigation officer is legally valid, Your Lordship. Your Lordship, section 154 clearly states that an FIR must be registered for the cognizable offences which has been approached to the police, Your Lordship. Your Lordship, in this particular case, the parent of Zena has been approached to the police station on a missing child person here, missing child case here, which is a non-cognizable offence here. Missing child cannot be always amounting to a crime here, Your Lordship. So, Your Lordship, it is a non-cognizable offence here, Your Lordship. So, the police has been taken a reasonable time to register an FIR here, Your Lordship. Your Lordship, in the case of Charan Singh versus State of Maharashtra, the court has made a preliminary exception for preliminary inquiry here, Your Lordship. Your Lordship, when a missing child person has been approached to the police can take a exception in registering FIR by a preliminary inquiry here, Your Lordship. In this particular case here, Your Lordship, in this particular case, there is a pre-history already found regarding Zena's missing here, Your Lordship. Your Lordship, Zena is a transgender here, Your Lordship. She has already been ran away from her house and
Transgender, okay, but she is minor.
Indeed, yes, Your Lordship.
Whether
Yes.
the POCSO Act is applicable to such case or not?
Your Lordship, as per the Transgender Rights Act 2 subclass, section 2 subclass A, it clearly states that transgender must not be considered as a woman or a male here. They should be considered as a third person here. Your Lordship, POCSO Act clearly states that offences relating to children of male and female gender here, Your Lordship. It does not include a third gender here, Your Lordship.
The act is gender neutral, not particularly only applicable to male or female. It is gender neutral. Act itself gender neutral.
Your Lordship, the council would like to take the help of the researcher here.
Yes, there is specific provision under section 121 of POCSO Act.
Your Lordship, as the POCSO Act is a general neutral act here, Your Lordship, but there is no specific provision is being established under the act for the transgenders here, Your Lordship. Your Lordship, as per the Arun Kumar case, which has been clearly stated, when there is no specific provision relating to the transgenders, the general provisions must be followed here, Your Lordship. And Your Lordship, the filing of 376 and 302, 377 and 302 in the case of Zena's murder case is quite valid here, Your Lordship. Much obliged, Your Lordship. Your Lordship, further, Your Lordship, in this case, as I mentioned earlier, there is a pre-history which has been occurred here, Your Lordship, where
As I submitted earlier, not as I mentioned earlier.
apologies, Your Lordship. As I submitted earlier, there is a pre-history which has been occurred in this particular Zena's missing case here, Your Lordship. Your Lordship, Zena is a transgender. She has been ran away from her house at a very small age and returned back after several months here, Your
She
Lordship.
said, Jana, she ran away.
Your Lordship, she is a transgender here, Your Lordship.
You need to say 377, I understand 377 is cognizable offence. So it is government duty of the police to register case as per section 154. Why he has refused to register the case?
Your Lordship, when the petitioner approached the police, they said that
Whether, with respect to the fact whether she is transgender or not, she is minor.
indeed, yes, Your Lordship. Your Lordship, when the petitioners approached the police station, they said they have been made a complaint only about the missing child case, Your Lordship. They have not mentioned any of the cognizable
What they
offences
have
here.
reacted.
Your Lordship,
What they have reacted. It
Yeah.
was just before statement of Jana's father. What he has said.
Your Lordship, he has said that he has approached the police station on behalf of his missing child here, Your Lordship.
What police said?
Your Lordship, police sent them to search for one more day and return back the next day here, Your Lordship.
Why it is so? Why
Your Lordship, as there is a pre-history
I
on
only proceed whether section 154 is attracted or not.
Your Lordship,
377 is cognizable offence.
indeed, yes, Your Lordship, but Your Lordship, at the initial stage, it is only a missing child case here, Your Lordship. It is a non-cognizable offence, so
No. Who said it is not cognizable offence? 377 cognizable offence.
Your Lordship, in the case of missing child case here, Your Lordship, Your Lordship, missing child case may not be amount to a crime all the times here, Your Lordship. Your Lordship, 154 is attracted, but after a reasonable time here, Your Lordship. Your Lordship, there is already existing a pre-history here as she has been managed from over, and the same complaint has been registered under the same police station and under the same inspector here, Your Lordship. So the police have been requested the parent to search for one more day and return back, and FIR has been registered on 16th of August here, Your Lordship. There was no delay here. Only the reasonable time has been considered here, Your Lordship. And Your Lordship, the Supreme Court has been stated given 24 hours as a reasonable time in case of a missing child cases here, Your Lordship. Your Lordship,
Counsel, Nagaruki Jana is mentioned as Sri or son, daughter.
Your Lordship, his father has been stated that Zena is a transgender here, Your Lordship. He was actually she was a male by birth, Your Lordship. She identified her sex as a female here, Your Lordship. So her predominant sex is a female here, Your Lordship.
Then why Moot Act is not applicable?
Your Lordship, as there is no particular procedure established under this Act, Your Lordship. As per already submitted by the council here, as per Arun Kumar case, when there is no specific provision established for the transgenders, common regular procedures should be considered here, Your Lordship. Hence, here IPC has been invoked here, Your Lordship. Much obvious, Your Lordship.
No, transgender also include in the POCSO Act.
Much obvious, Your Lordship.
Section 2 of POCSO Act.
Much obvious, Your Lordship. Shall I proceed with the case? Much obliged, Your Lordship. Your Lordship, as per the Tamil Nadu police standing orders, it clearly states that order number 370 subclass 7D, it clearly states that when a person approaches the police in case of a missing child case, it is only to be registered under the station's general diary here, Your Lordship. Only after the reasonable time or a particular preliminary inquiry only, FIR to be registered here, Your Lordship. Further, Your Lordship, it is also stated by the order number 834, sub-inspector's instruction to the section officers here, Your Lordship, which also quietly states the same, Your Lordship, as whether reports of missing children should be entered under the section general diary regarding all such matters here, Your Lordship. Further, Your Lordship, in this particular case, Your Lordship, the petitioners have approached the police station only regarding the missing child case here, Your Lordship. They have not approached for a cognizable offence, which has been mentioned in the area 377 or 302 here, Your Lordship. So, Your Lordship, at the initial stage, the police has been taken a reasonable time here, Your Lordship. So, it is not amount to violation of any legal duty bound by the police here, Your Lordship. Therefore, Your Lordship, it is humbly submitted that the arrest warrant issued to the investigation officer is not legally valid here, Your Lordship. Your Lordship, the council seeks permission to want to pay. Much obliged, Your Lordship. Your Lordship, in the light of the issues raised, argument advanced, authority cited, we pray before this Honorable High Court of Afghanistan to allow the petitions filed under 482 of CRPC and to declare that the challenge to the legal proceedings and the arrest warrant issued to the investigation officer is not legally valid here, Your Lordship. For any order passed by the High Court of Afghanistan, it is the duty to bound forever by the counsel of the petitioners, Your Lordship. Much obliged.
Only final two clarifications.
Yes, Your Lordship.
So, question number 1, do you have referred Menegaman versus Union of India's case?
Yes.
No, you can simply answer,
Much obliged, Your Lordships. In this particular case, Article 21 has been established and the procedure established by law should be followed while violating the fundamental right which has been granted as Article 21, Your Lordships. But in this present case, bail is a fundamental right, Your Lordships. It has been upheld in the case of Ritu's case in the year 2022, Your Lordships. This particular case, right to bail is a fundamental
Okay,
right.
second clarification. Your co-counsel submitted Sharan Singh versus State of Maharashtra. Have you referred the same in your memorial, which should know?
Indeed, no, Your Lordship.
Okay, thank you.
Much obliged, Your Lordship.
Sponsor here, only 6 months, judicial review.
Reading to the bench, this is Counsel 1, appearing on behalf of the respondent. Indian Mail Option. The Counsel humbly seeks permission to address the bench collectively as Lordship and Ladyship. Much obliged, my Lordship. Before the Honorable High Court of Afghanistan, under the petitioners have invoked under Article 4, under Section 482, Section of the Code of Criminal Procedure in the year 1973, and the matter between Varun as petitioner and this is State of Afghanistan as respondent, and combining and clubbing the petition of the matter of Iridore as petitioner, this is State of Afghanistan as respondent. The Council here contend that without alternate counsel would have invoked under Article 226 of the Constitution instead of Section 482 of the Criminal CRPC, my Lordship. If the bench is satisfied, the Council would humbly move on to the statement of facts. Indian Mail Option. Varun, aged 17 years, with a spread towel, snatched a chain of Marina and owed the men and being succumbed of injuries. The case later turned to a murder investigation inculcating Section 302 of IPC. And Varun, being juvenile, initially arrested under Section 379 and 397 of Indian Penal Code and granted bail. But due to the injuries, Marina died, and which prompted the court to cancel the bail due to the insertion of Section 302 of IPC. And parallelly, in the missing person Zana case, aged below 17 years, the transgender individual found to be murdered and harpooned. Subsequently, when the motorcycle of Varun, a juvenile, was found in the ambit of 1 kilometer distance, and the autopsy report of the Zana revealed pre-mortem sexual abuse, Your Lordship, and followed which led to filing of Section 377 and 302 of IPC. And amidst this kind of circumstances, upon statement made by Paramu, father of Zena, showed that the negligence from the police side in the dealing of the Zena case, leading to warrant against investigation officer, petitioner in the particular case, Vilayadhara Lordship. The bench is satisfied, the Council would humbly begin with the issues raised. Much obliged, my Lordship. Issue 1 is that whether the offence mentioned in the FIR is made up, and issue 2 is that whether the legal proceeding in the chain snatching case complied with criminal justice system, and issue 3 is that whether the cancellation of bail violating any rights of the offender, and issue 4 is that included by the respondent side, whether legal proceeding in the Zena murder case complied with the criminal justice system, and issue 5 is that whether the arrest warrant issued to the investigation officer is legally valid. Issue 1 and 2 will be dealt by the Council 1 myself, and issue 3 and 4, 5 will be dealt by my co-counsel. The bench is satisfied, the Council humbly seeks permission to begin with the arguments advanced of issue 1. Much obliged, my Lordship. Issue 1 is that whether the offence mentioned in the FIR is made up. It is humbly submitted that the offence is mentioned in the particular FIR is everything is made up in here, my Lordship, including Section 397, 379 and 302, your Lordship. Here the Council humbly submits the basic prima facie CCTV evidence, which is fulfilling the prima facie test in the particular case of the particular proposition, my Lordship, where it is clearly stated sufficient evidence to establish that the crime has been committed and that the accused is likely to be responsible for the crime by presenting sufficient and non-contradicting evidence, my Lordship. And here, to meet the prima facie evidence, which is a primary evidence, prosecution must have present enough evidence on each element of the offence to support the conviction, such as actus reus and mens rea, causation and concurrence and harm, your Lordship. And if the evidence were to present no evidence, is incomplete in response, your Lordship. And here the Council humbly directs the court to refer to the compendium 15 flag 1, where it provides that the CCTV is the strong evidence to prove the particular prima facie fact, my Lordship. The Council humbly begins with the insertion of Section 302 for the particular case, my Lordship.
One doubt, Council.
Indian, my Lordship.
One doubt, Council.
Much obliged, my Lordship.
Why this 79 has been invoked instead of invoking one of the key offenses, Section 393 is there.
My Lordship, here the Council would elaborately clearly state that Section 379 is the only section which can be inculcated for the
You
particular
read
case.
Section 393. whether commission of offence has been full-fledged or not.
which is involving grievous hurt with the use of weapon, my lordship.
Then additionally you have added 397, which is amounting to robbery.
What section says 379 IPC?
My lordship, the section 379 is clear. The council will refer to the preposition where it has the FIR has been filed, my lordship. And
Council, please answer to Susan. What are the constituent element of 379 of IPC? Don't return to what compromise says.
indeed, my
Compromise
lordship.
says 4 sections. But when you started, it said only 3 sections. I don't know if you happily miss 377.
My lordship here,
Therefore, you also you have mentioned only 3 sections.
my lordship, section 377 is
379.
379.
much obeyed, my lordship.
What are the ingredients made in the 379?
Indeed, my lordship. Lordship. The section 379 which clearly states out
Whether the witness necessary for theft under section 379 IPC?
my ladyship, here the attempt to commit the chain snatching is absolute theft, my ladyship, which has been clear is even the primary evidence of the CCTV clearly states that.
First of all, the prosecution has registered a case under section 379 IPC.
Indeed,
as well as
madam.
397 IPC.
Indeed, my ladyship. Indeed, my ladyship.
Okay.
Indeed, my ladyship. Here the council humbly submits the section 397 of IPC and the ingredients of the particular have been fulfilled in your ladyship, where it clearly
Please
states.
answer to my brother,
Why 393 has not been invoked? You should have very well invoked section 393 instead of 379.
Because the word robbery is used in both the sections, 93 and 97.
When specific offence is made out as per prosecution case, why 379 has been invoked?
My lordship, it is clear, humbly submitted. Here, the section 393 clearly states attempt to commit robbery only, my lordship. But whereas in the section 397, it clearly states with attempt to cause death and grievous hurt, my lordship. Whereas in the particular case, it has been fulfilled with an element. The council humbly directs the bench to refer to the paragraph 7 of the proposition, which clearly states that the accused got angry and could not understand what he could do, and so he flee from the spot before he could be caught. And whereas the rider of the bike accelerated in full swing and she was dragged on road, my lordship.
Yes, but when they left, she was lying.
My lordship, she was accompanied with severe injuries, my lordship, which is there were 8 cuts on her body from hands to neck, and the council humbly submits a compendium of the medical legal, which clarifies the data where when the woman has where her chain has been snatched and succumbed injuries would lead to absolute death, my lordship. But she was in the situation where her injuries were highly moderate. But later, after 10 days of after the admission into the hospital, she was died subsequently days.
Simply I asking you, what is different between 379 IPC and the 397 IPC?
Indeed, my ladyship,
Already I asking you whether 379 IPC direct witness necessary or not.
my ladyship,
That's why I asked you this question.
indeed, my ladyship, here particularly here in the case of Marina's chain snatching case, we don't have a direct witness on a person, but we have some primary evidence of CCTV footage, my ladyship.
Marina is a direct witness. He is a victim as well as the direct witness in the case.
My ladyship, she is the only person who was the victim for the particular case, my ladyship, and she was accompanied with injuries also, my ladyship.
It is not a prosecution case that property has been recovered.
My lordship,
It is
the
mere
case.
attempt.
My lordship, it has been clearly stated in the CCTV in the paragraph 8 where say face falling onto road and the grab when 2 men on a moving motorcycle snatched her jewels, my lordship, which clearly states that the primary evidence proves that the chain has been snatched, my lordship.
No, there is no.
It is not. It was not taken.
It was not taken. Your prosecution version itself said it has not been taken.
My lordship,
It was mere attempt.
What is the final element
As
of
the prosecution case, Marina hold the chain on the neck
It was not taken by.
How you establish 379 of IPC? Have any property recovered from the accused who was?
Beg your pardon, my lordship.
Is there any property recovered from Varun?
Chain has not been snatched. It was attempted to snatch.
Was it taken away by them?
I think you have misunderstood the
Indeed,
prosecution.
much obliged, my lordship. Indeed, no, my lordship, because here the council would like to elaborate with which permissively with a particular incident what happened in practical in the purpose in the ambit of the proposition, my lordship. So which permits?
Your actual proposition says chain has not been snatched.
My lordship, here the council humbly submits that kindly here in the particular CCTV footage it has been proved that the chain has been snatched, my lordship. But here in the subsequent
Attempted, not snatched.
Not snatched,
Okay,
only attempted.
whether property was recovered from Varun, whether the same chain which Megna owned was recovered from Varun by the prosecution.
my lordship here the particular
That is the PW. You are marked as what?
my lordship there is no information about the possession of goods, my lordship. It can't be presumed by the council in your arguing, my lordship, because of the particular.
Prosecution too. Because without fulfilling the constitutional elements of the section, there are the choices for you. That's what the council was the petition appeal recorded. The criminal administrative system was not properly managed by the state.
My lordship, here the council would refer to a previous paragraph which proves the.
Say paragraph number when I say.
Indeed, my lordship.
You just read paragraph number 50 in Varun version, where he has specifically mentioned last line part of it. Moreover, he told me that he had not snatched that chain. After he seen it becomes normal. So it means
Statement have to be proved. Beyond reasonable doubt, right?
Indeed, my
That is
lordship.
the corroboration by saying whatever Varun did is happily recovered from him.
My lordship, here the council proves the criminal antecedent of the particular the particular person who is here as Varun, my lordship. It clearly in the paragraph.
You state the full antecedent is a ground to prosecute.
My lordship, it is not the exact wrong, my lordship, but here the council humbly submits with an argument where it proves that it has a criminal antecedent and where it is clearly stated in this paragraph 7 of the proposition where she was dragged on the road that snatchers nonchalantly sped away, which clearly proves that the snatchers, the word snatchers, which clearly states that there is a two men and it's not definitely one man who can lie with criminal individual liability, my lordship, where it clearly states there were two persons and both the persons are the criminal antecedents, and the word nonchalantly, which was described and defined in the Black Laws Dictionary, clearly states that it is the meaning of calm and composed. But here, where does it lie that the particular person, Varun, does not have any criminal antecedent or who was where he can be treated as a juvenile, my lordship? It is clearly stated that the particular person snatched the chain in the paragraph 8 and also where it led to the succumbed injuries in the paragraph 9 and which clearly proved, which is even proved by the primary evidence of section of the paragraph 8 of the CCTV footage, my lordship.
you just
And
read
here
paragraph
particularly.
7. Paragraph 7, you just read.
Just told you that the chain has been snatched.
Pardon, beg your
Para
pardon.
7, para 7.
7
Indeed, my lordship.
on 8th August.
Indeed, my lordship, it clearly states that the particular situation which happened in the case of Marina chain snatching case, my lordship.
This council ignore everything. Where is the property record from Varun?
My lordship, the case.
Marked as evidence or not? There is a number.
Material update.
Indeed, my ladyship, the council here humbly submits that the case is still under premature stage of investigation, my lordship. Yet, we just got this, and particularly, and in this premature stage, the petitioners have invoked under section 482 of to inherit the power of the High Court, where it clearly, where it highly interprets the investigation, where it absolutely intends in the procedure to be followed and continued in this investigation procedure, my lordship. And whereas the possession of goods is not yet discovered, and still we have issued a warrant against the Tarun to be yet where he has to be discovered, my lordship. And here the council would humbly submit that in the section 3, the council would humbly move on to the section 397, which has clearly states that the the FIR is made out where robbery or recorded with the attempt to cause death or grievous hurt, my lordship. Where clearly here the council humbly submits the three ingredients being made out, your lordship, my lordship. First one is that uses any deadly weapon, and second one is which causes grievous hurt to any person, which is observed a common intention, which is even proved in the case of where it is completely proved that in comparative to section 34 where there is a common object and also there is a common element to be
Whether
present.
they are used deadly weapon, whether using by this deadly weapon.
Indeed, my lordship, the council here humbly submits with an important situation where happened in the proposition, my lordship. Here, the
First
council.
of all, what's the proof? Then only robbery would come.
My lordship, the theft has occurred where there is a chain snatching.
It's mere attempt.
My lordship, it is not clearly proved here there is an attempt, my lordship.
Please go to paragraph number 15, your 64 statement given by Varun. Okay?
Indeed, my lordship.
Paragraph number 15.
Your prosecution case itself says chain had not been snatched.
Yes, sir, that's what I both asked you to read.
Again and again we are asking you.
Second paragraph, some 10 lines from the bottom. So, he told me that he had not snatched the chain
My lordship.
after he seen her a face of an old woman. As he looked, it was very sad. Then only my breath became normal.
My lordship, here the council humbly submits that the one of the particular major element, the confession made under section 164 to the magistrate is can be acceptable, my lordship. But here, only the particular.
She could recover alone, then confession is admissible. Section 27 evidence says
Indeed, the council humbly submits that.
64 statement, not
Indeed,
confession.
Indeed, pardon me, lordship. And here the council humbly continues with the submission is that this is the statement given by the Varun only, my lordship,
Yes.
but not by Tarun. And here we have important particular character.
Against whom FIR is filed, whether Tarun or Varun.
And the FIR has been filed against both of them, my lordship, after discovering the CCTV evidence, my lordship.
Okay.
Indeed, my lordship. Here the council humbly submits, in the case of Sanjeev Nanda versus the estate of NCT Delhi, which in the year 2009, which clearly states that such like circumstances where the accused intended to kill the victim due to some prior animosity by using a motor vehicle as a weapon of offense to attract section 300 itself, my lordship, where section 300 is an absolute murder, my lordship. To the kind perusal of the court, the council humbly submits. The council humbly requests the bench to extend of 5 minutes to complete with their arguments here, my lordship. Indeed, my lordship. And here in this particular element is absolutely proved that a vehicle can be a weapon to cause a grievous hurt, my lordship, where the council once again clearly states that the accused got angry and could not understand what to do and he accelerated the motor vehicle in full swing and she was dragged on road, where a horrifying video which is an absolute evidence when the social grade was established, my lordship, where a woman can be seen falling face first onto road and dragged when two men were moving on a motorcycle. And here the weapon has been used as here the bike has been used as a weapon where it clearly proves the instrument under the section 397 of Indian Penal Code, my lordship.
What's your argument or your friends' arguments saying that only jurisdictional court is only one in the six but not concerned magistrate court?
I beg your pardon, my lordship.
What is the jurisdictional court is only dwelling district court, dwelling district court, not magistrate court.
Indeed, my lordship, here the council humbly submits the Tamil Nadu Juvenile Justice Care and Protection of Children Rules 2017 in reference to Rule 9 clause 22, which clearly states that it can be taken into account mental health reports including an assessment of the cognitive maturity of the child, my lordship. Read with the section, Dr. Subramanian versus a member of Juvenile Justice Committee, which clearly states the true test of the juvenility is not in the age but in the level of mental maturity that a particular person possesses, my lordship.
Whether it gives jurisdiction to magistrate court?
My lordship, here in the particular case, then there is no exact, the council humbly submits to the perusal of the reference for the particular case. In the particular case, there is only the word court has been mentioned in the facts, my lordship. There is no clarity whether it is a children's court or the magistrate court, my lordship. But here the police officer arrested the particular petitioner to produce him before the court just to for the preliminary assessment, my lordship, and which can be proved in the court of law in the further investigation whether he is eligible or not, my lordship. But accordingly, this is what he has committed is a heinous crime, my lordship, where the heinous crime can be defined when there is 7 years of plus punishment for the particular crime committed by the offender, my lordship. If the bench is satisfied, the council humbly move on to the second issue for the particular arguments, my lordship. Indeed, much obliged, my lordship. And here the council humbly submits in the case of state of Andhra Pradesh vs. Sakitram Reddy and others, where it clearly states the omnibus statement about the culpability of the accused in the testimony of the prosecution witness and would be the circumstances which prove the corroboration of the medical evidences for the perusal of
Which one of the memo you are referring? What's the proposed number?
my lordship. Here the council would be submitting the perusal for the court.
It is not mentioned on the memo.
Indeed, my lordship, the council is submitting as a compendium, my lordship. Issue 2 is that whether the legal proceeding in the chain snatching case complied with the criminal justice system, my lordship. It is humbly submitted that the chain snatching case complied with the criminal justice system, my lordship. Here, basically, in the country of Himalaya and state of Maharashtra, which is parliamentary to the state of Tamil Nadu, has the basic identification of an adult under 2 categories, my lordship. First one is that on the basis of the voter ID issued by the government, and second by the driving license issued by the government, my lordship, which clearly states that there is an presumption which is valid under the Indian Evidence Act that indeed, my lordship, where he himself has clearly stated in the paragraph 15 in line 6, where he clearly states that to get a driving license, and it was easy to me to get driving license irrespective of my age, and it wanted to fulfill my aspiration to own a motorcycle, nothing more than that, my lordship. Which clearly proves that he has a possession of driving license, my lordship, and this kind of possession of driving license is validated by the presumption in the Indian Evidence Act, and also the section 4 of the Motor Vehicles Act 1988 clearly states that the age limit in the connection with driving license and the driving of motor vehicles, which validate the photo ID or any ID issued by the government and is possessed by the Varun is a basic prima facie evidence, and the arrest by police is considered as an adult, my lordship. For the kind condition of the court, the council humbly submits to the barrack. The council humbly submits there is a gravity of offence which is committed by the child is an indicator of the maturity, and the second is that the accurate determination of maturity is possible as submitted in the juvenile justice rules of Tamil Nadu in the Gazette, my lordship. And here it is absolutely against the principle of presumption of innocence and the cardinal rule of fair trial, my lordship. And here the council humbly concludes that the child committing a heinous crime would require more intensive scrutiny and ought not to be treated similarly to children committing less heinous crime for the public safety and morality, my lordship. If the bench is satisfied, the council would rest their arguments and invite the co-counsel for the further argument 3, 4 and 5, my lordship. Much obliged, my lordship. It was honored to argue before this court of law.
Greetings to the bench. This is counsel number 2, appearing on behalf of the House Office of Respondents to discuss about the issue number 3, 4 and 5. Issue number 3, whether the cancellation of bail affects the rights of the offender. Your Lordship, it is to be submitted before this court under 3 forms of arguments. First one is, the court inserted the provision of section 302 of IPC into the prior first FIR and then consequently cancelled the bail. It is proved from the fact sheet point number 16 to be read with your Lordship. Section 302 inserted in the FIR consequently, the court cancelled the bail for the Varun on 29th August it is to be construed that it is the action of court to insert the particular provision. It is called alteration of FAR. Your Lordship, in a case called T.T. Anthony vs. State of Kerala, a case where the FAR mentioned a cognizable offence under section 302 or 326 IPC in that particular case, and the investigation agency learns during the investigation, receives a fresh information that is the victim died, then there is no need for the registering a new FAR, and in such case, the alteration of provision of law in the first FAR is the proper course to adopt. It is to be submitted for the review of this court. Your Lordship, here in the pertaining case, the insertion of section 302 into the first FAR is legally valid, and consequently, the subsequent crime has happened here is proved. Your Lordship, if any subsequent crime happening at the time of bail period, the bail which was issued prior will be automatically cancelled according to before the eyes of law. Your Lordship, it is also dealt in the case of Deepak Yadav, whereas the cancellation of bails, the court issued some guidelines to cancel the bail under some of the categories. It is also to be submitted before this court. Your Lordship, it is to be proved to the bench with the judgment, that is the latest judgment, that is a Pradeep Ram vs. State of Jharkhand. It is issued on 2019. They relied upon a judgment called Hamida vs. Rashid. In this judgment, an accused, after the addition of serious non-cognizable offence, is required to surrender and apply for the new bail. If there is an alteration of FAR happened in the first FAR, that should be the filing of a new bail to be happened. The failure is on the side of petitioners, and they are invoking 482 to quash entire FAR and to stop the legal proceeding to save his front term. Your Lordship, it is also to be submitted at the same judgment itself. It is consequently said, in such circumstances, the High Court committed manifest error of law by entertaining a petition under 482 CRPC and issuing a direction to the subordinate court to accept the sureties and bail bonds for the offences under the sections of IPC. It is also submitted for the perusal of this court. Your Lordship, from all this interference, it is to be construed that cancellation of bail in this pertaining case after the insertion of section 302 doesn't violate any right of the offenders. If the bench is satisfied, the counsel will be moved to the next part of the.
Which also one thought.
Yes.
Bail is for particular claim number or where bail is for particular section.
The bail is for particular crime number, Your Lordship.
Why you cancel?
Your Lordship, if any heinous offence or cognizable offence added as a subsequent crime in between the period.
One offence is made out. One AR has been registered. Then after investigation and section 173 subsequently police will file final report. By adding some other offences. Then accused whether they have to get another bail or another anticipated bail application for a separate offences.
Your Lordship, here in this particular case, the investigation is not even started, is in the premature stage.
It has been granted.
Your Lordship, the final report is not yet submitted before the eyes of law, and the bail is granted through
You are producing judgment against.
Indeed, Your Lordship, that is.
Maybe Antony case, you are producing judgment wherein the section has been added in final report.
Indeed, Your Lordship, to be added to the point as an answer to this question, our learned opponents actually claim a frivolous and contrary statement. That is, their first speaker want Varun, that is accused, to be tried in the JJB, that is the Juvenile Justice Court. Hereby, it is done in the criminal court or the child's court. That is not clear and it is ambiguous in the particular fact. But the second speaker claims that bail was given by the child court under JJ Act by invoking section 27. In their memorial, they used section 27 of CRPC. Here to read with the section 27 of CRPC, the jurisdiction in the case of juveniles only entertain whomever the person under the age of 16 years. Whether Varun is under the age of 16 years? No. Hence the bail is given by the court that he applied for the bail, and the presumption of the petitioners is malicious before the eyes of law.
Council, I asked you.
Idiot.
With respect to cancellation oil, under section 437 of class 5,
Idiot.
and breach of contract condition arrest, cancellation as paid comes under this section.
Thank you.
Which condition?
Your Lordship, the council understood the question. Your Lordship, it is the Indeed, yes, Your Lordship. Apart from all the guidelines issued, even under the Satyendra until Mrs. CBI, the court could consider whenever the subsequent crime or new offence which is cognizable and non-bailable is added during the investigation, the bail which is issued to the accused should be cancelled and he should be kept under custody because to stop tampering the evidences outside and saving his co-accused, Your Lordship.
Second question, United Justice Court can invoke under section 437 class 5 here.
Indeed, yes, Your Lordship. Indeed, yes, the council admits what a court get the inference, but right now, the police side in the premature stage understood that Varun is an adult who is having a government issued ID certificate, Your Lordship.
Whether without providing any opportunity to Varun, whether bail has been cancelled.
It did not, Your Lordship. The court actually abide by the rule of law, Your Lordship. From the cancellation of bail clause,
In para number 16,
it is not mentioned, Your Lordship.
It had not been mentioned whether proper opportunity has been given or not.
Your Lordship, the fact is cited and council
Council has been added, we have cancelled the bail application.
Indeed, yes, Your Lordship. The court cancelled the bail and court inserted the 302. It is not the action of police, Your Lordship. And to be answered, the fact is very cancellation of bail in this pertaining case is sustainable and it is not frivolous under the act. Your Lordship, to be moving in the next issue, that is whether the legal proceedings in Zena murder case complied with the criminal justice system. This issue is added for the benefit of the respondent side. Your Lordship, this issue is to be construed in a twofold of arguments. First one is, here the sexual assault was happened against a minor transgender called Zena. Your Lordship, in POCSO Act, that is the Prevention of Children from Sexual Offences Act 2012, it is very clear with its section 19 clause 2. Your Lordship, to be reader for the perusal of this code. Your Lordship, reporting an offence is given as a procedure in the POCSO Act as clause 2 of the 19 says every report given under the subsection 1 shall be ascribed an entry number and recording in writing, be read over the informant and shall be entered in the book to be kept in the police unit, and if they fails to do, section 21 gives a punishment for failure to report. Your Lordship, that is the happening of penetrative sexual assault is proved here. As the petitioners claim, it is a carnal intercourse. There is no bar under this act to file the case. Your Lordship, to be proving this, section 2 clause D includes the word child. Child means any person below the age of 18 years. It includes the third gender. And the next thing is section 6, punishment for the aggravated penetrative sexual assault.
You yourself making a contradictory statement. Just before we said Varun is not a minor because he has a government account. Now you are saying you are saying it can be understood.
Your Lordship, to be justified with this, the Varun's chain snatching case is held by the town police and the Zena murder case could be held by the Karaval police.
Varun is a major or minor?
He is major, Your Lordship, because under the eyes of law, he should be considered as an adult in this premature investigation. If court considers him as a minor,
What is the point in speaking a JJ?
But section 27 CRPC not says like that. In case if there is any specific provision, then it will be dealt with only under the specific law.
highly obliged, Your Lordship, the council differ with the statement of the bench because a special law is enacted after the shocking judgment from Nirbhaya, and this act enacted in 2012 is a special law. When the special law prevails or the general law prevails, the race could be won by the special law. And this particular act should be invoked in this particular legal proceeding. And section 6, the punishment which extended up to the death penalty should be here for the legal proceeding, which is violated by the investigative officer Veeradura in this pertaining matter, Your Lordship. To be added, also the Transgender Protections Act 2019, it is also came into force after the legal fight from the NAS Foundation and other judgments. Here also section 18 gives the offences and penalties to be read with your lordship. The 18 clause D here gives the sexual abuse punishment for up to 6 months. It is to be added with the given punishment under the POCSO, and these two provisions to be invoked in this pertaining legal proceeding, and the police side, that is investigation officer Mr. Veeradurai, vehemently violated this, your lordship. To be proving this point, the council will also clears that here, your lordship, there was a prior complaint filed in this Karavalur police station before itself about the missing of their son. It is the second complaint filed before this particular police station, the same police station, about the missing of their own children. Your lordship, to be scrutinizing this point, how carelessly and lethargically the particular police station and the station of officers are working in the station. This is the scenario in most of the police stations in rural area. Your lordship, if the bench is satisfied with this particular issue arguments, the council move on to the issue number 5, which is pertaining to the issuance of arrest warrant by the court. Indeed, yes, your
Is there any provision to issue warrant against
Indeed, yes, your
investigation
lordship.
officer due to not bad
Indeed, yes.
investigation, sir?
Indeed, yes, your lordship, that should be dealt by the council in this pertaining issue. This is issue number 5, whether the arrest warrant issued to the investigating officer is legally valid or not. Your lordship, this issue to be dealt with a twofold of arguments. First one is arrest warrant issued to the investigation officer through the appropriate official under the form C of section 70 in CRPC. It is legally valid because of the delay in filing of FIR. The next fold should be invoking the provision 482 to quash the arrest warrant is pretty and funny, because 482 is only on the ambit to quash FIR's complaint and the legal proceedings. Arrest warrant here, it is a court order, that is a subordinate court order. They would have been filing the 220 under the 226 case to get the writ of certiorari to strike down the court order, but they failed to do so. They came here to invoke the inherent powers of this court to misuse the miscarriage of justice. The lordship, to be enunciating this, the council will be submitting few case laws, whereas it is stated the delay in filing the FIR is fatal to the prosecution case. Your lordship, from the fact sheet number 13, it is very clearly stated that after the autopsy report confirmed that particular child is a transgender, aged between 16 to 17, and she was sexually abused before her death and burned. Your lordship, after hearing this, how come the investigation officer invoking section 377 and 302 and filing the FIR afterward? Because the complaint was first of all initiated on 14th August 2023, and they gave a lame exception that tomorrow is a national important celebration and we can't file. But each and every station house officer under the section 154, they are obliged to register the FIR. And then your lordship, even on 16th August, which is the date fixed by the police officer to come and give the complaint, they didn't file the FIR. Your lordship, it is noted on point number 10. On 16th August, the Karavalur police received a complaint given by their parents about the missing of Zena, the transgender. She was not found in last 2 days. Zena is an active social media, and another paragraph is continuing, but on 16 itself, there is no FIR is registered, your lordship, and the police took the complaint from your lordship. Why this much of delay in filing the FIR and proceeding the investigation in this particular case? There are alternative remedies, your lordship. The council accepts this under the article 153 class 3 or else a 200 private complaint. But this court, scrutinizing all these inappropriate proceedings before this matter, and the court summarily issued the arrest warrant against the investigation officer Veeradurai, and we humbly pray before this court to transfer this particular case to crime branch or any other CID to get a justice for the rape sheriff. Your lordship, to be added from the
issuance of warrant is justifiable
Indeed,
and
yes.
is very insubstantial state.
Indeed, yes, your lordship. Your lordship.
How do you say?
Indeed, yes, your lordship. Your lordship. Here, the delay in filing the FIR, by delaying filing the FIR, the police official committed an offence under IPC section 166A. Your Lordship, the 166A to be read with.
That case can be registered. Then why you issued warrant of arrest?
Indeed, yes, Your Lordship. The
166A case can be registered.
Indeed, yes, Your Lordship.
Under section 70 subclass 3 CRPC, how do you issue warrant as against investigating officer?
Your Lordship, to stop the miscarriage of justice and to transfer this particular case to some other investigation officer who is abide by the public duty, or to transfer this case to the crime branch or CID to proceed the investigation further in rapid course, because the speedy trial is a fundamental right recognized by the same court, Your Lordship. Your Lordship, to be
Investigation officer may be changed.
Indeed, yes, Your Lordship. Your Lordship, here in the case of Bijoy versus State of West Bengal, it is very clearly stated that the failure to register the first information report in respect to the offences punishable under section 4, 6, 7, 10 and 12 of POCSO shall attract a penal liability under section 166 of IPC. That is how the arrest warrant is issued here, Your Lordship, for the perusal of this court. There is no compliance by the police officials to register this case under POCSO, whereas it abruptly falls under section 6 of the POCSO, Your Lordship. To be, Your Lordship, if the bench is having any question. Your Lordship, if the bench is having any question, the counsel is duty bound to explain. Your Lordship, if the bench satisfies this sufficient argument, the counsel will move on to the prayer. Indeed, yes, Your Lordship. Your Lordship, whether in the lights of issues raised, argument advanced, and authorities cited, the House of Respondents humbly pray before the Honorable Court of Judicature of Manastan to dismiss the present petition and impose an exemplary cost to pay over the loss of the lives of deceased victims as a compensation to them, and pass any other order it may deem fit in the interest of justice, equity, and due process. It's my pleasure to argue. Indeed, yes, sir.
What is the need for making some article 226 of law?
Indeed, yes, Your Lordship, here, as a petitioner, our side file this case under 482, section 482 of CRPC to be read with article 226 to issue the writ of certiorari to the lower courts to cancel the arrest warrant, which is an court order here. It is not a legal proceeding, Your Lordship. Indeed, yes, Your Lordship. Here, Your Lordship, as a petitioners, we invoked in that particular section because we recognize fundamental right of personal liberty is violated in that particular case in the petitioners, and we invoked Your Lordship. Under the Constitution of India, Your Lordship. Your Lordship, Article 21 guarantees the fundamental liberty, personal liberty to the Indeed, yes, Your Lordship, it is a procedure established by under procedure established. Indeed, yes, Your Lordship. Your Lordship, the law includes from the Article 12, it includes all the rules and regulations, Your Lordship. Here, Tamil Nadu Criminal Procedure and Indeed, Your Lordship, 13, Your Lordship. Indeed, yes, Your Lordship. Here, Your Lordship. Your Lordship, Article 13 clearly states that law includes all the ambit of rules and regulations. Here, Tamil Nadu Criminal Practice and Procedures and then Tamil Nadu Standing Order for Police issued the powers and duties to them. The Lordship, as a respondent here.
You said here the
Indeed, yes.
violated.
Indeed, yes, Your Lordship.
Violated subject to law.
Indeed, yes. Indeed, yes, Your Lordship. Under Constitution itself guarantees his freedom, Your Lordship.
Which article of Constitution guarantees freedom?
Article 14, Your Lordship.
Second clarification.
Indeed, yes.
Concluded with the compensation.
Indeed.
Which law permits you to claim a compensation?
Your Lordship, here in the proceedings of Zena murder case, it doesn't comply with the criminal justice system. because there is no victim compensation was given under the Victim Compensation Act, Your Lordship. That is how the prayer before this bench itself, the petitioners abruptly waste the time of this specious court must give the compensation to the deceased victim, that is Zena, for this mishappening. The council takes ignorance, the council takes ignorance, Your Lordship. Council will learn subsequently. Your Lordship, the bench asks further questions, the council will be duty bound.
Yes, you can start with the remedy.
Public my Lordship.
We go with the rebuttals. There are certain questions which has been arised on the side of the petitioners here, Your Lordships. And the first one is that is an alternative remedy available under the under the section 482 of CRPC, Your Lordships. The respondent are trying to invoke the Article 226 of the Constitution that there is no fundamental rights has been violated on the side of bail.
226. Are there any other article from the Constitution eligible to exhaust the remedy as an alternative?
Much of this, my Lordships, in this particular case.
Say the article. If you say 226 is not, are there any article facilitating them to claim?
There is no particular article which quashes the order of the court, my Lordships, until there is a writ of mandamus and a writ of certiorari, my Lordships. Here, using the writ of mandamus and certiorari, the court's proceedings can be quashed or executed to order to do or not to do an act something, my Lordships. Much of it, my Lordships. So they added up Article 226 in their memorial as the jurisdiction, my Lordships. How could it be invoked? And the second question is that they are solely relying on the CCTV evidence here, my Lordships. And the Marina's husband, Mesudas, has stated that she saw the face of the person who is riding the bike who was not wearing a mask here. And based on the CCTV evidence, if he was not wearing a mask, it will be clear in the CCTV that he is the particular offender here, my Lordships. But there is no clear CCTV footage here. Then what is the corroborative value of this particular CCTV footage here, my Lordships? And the third question is, they use the term deadly weapons, my Lordships. In this particular case, there is no deadly weapon is being used here, my Lordships. How could they justify this, my Lordships? And the fourth question, much of this, my Lordships. And the
was admitted to the under 164. That is covered along with the Darun and the Darun statute.
Indeed, yes, my Lordships. But the section 397 is confined to the particular offender here, my Lordships. So how they are invoking the constructive liability in this particular section on the name of Barun here, my Lordships. That is what the petition is contended to ask, my Lordships. And the fourth question is, there is a lack of direct evidence here, my Lordships. The petitioners are in the contention, the respondents are in the contention that if a person is standing before a wine shop, then they would call him a drunkard. They are proving the facts in that concern, my Lordships, because the much of my Lordships, since the term snatchers is a simple derogative term here, my Lordships. So based on the term snatchers, they could not constitute the criminal liability here, my Lordships. And the fifth question is, if an adult is involved in a juvenile, adult is involved with the juvenile in a particular case, the FIR can be filed, my Lordships, and then the proceedings need to be split up, and the juvenile should be treated in the juvenile justice court, and the adult proceedings should be carried out in the.
Already both of them made it since he has a driving license. It's a proof to make he is a major.
Much obliged, my Lordships. And
What do you say, section 27 CRPC?
much obliged, my Lordships. There is no particular mention of section 27 CRPC in our memorial, my Lordships, but the respondents are misguiding the court by. The learned respondent counsel are trying to misguide this court by quoting the section 27 of CRPC as we have stated in our memorial, my Lordships. And in this particular case, here the respondent, the learned respondent counsel contended that we are trying to save Tarun here, my lordship, which is I think they are not clear in the facts, my lordship, since because all the statements made by Varun are in the state of accusing Tarun here, my lordship. Then how they can say that we are trying to save Tarun here, my lordship, since because the FIR has been filed on the name of both the persons, my lordship. So we are not asking to quash the FIR here, my lordship. Our prayer is the cancellation of bail should be quashed, and at the same time the Varun should be excluded from the FIR alone, my lordship. That's what we prayed before this Honorable High Court. But they are misleading the court by quoting the statement made by Varun, my lordship, and they have made the statement about the Varun statement, my lordship.
They cannot simply excuse it. This is statement given under 164.
Yes, my lordship. There is a lack of corroboration evidence, my lordship. Okay.
Not necessarily 164 CRPC statement. It is before magistrate.
Yes, my lordship. There is a lack of evidence, my lordship. Since there is a lack of evidence.
That's what we are repeatedly instructing into the paragraph 15.
Yes, my lordship.
Four lines are attempted by Varun before the magistrate of the 164 statement. Admitted fact may not be proved.
Much obliged, my lordship. The respondent counsel stated that the statement made before this court that Varun has acquired a license, but they have split up the statement of license because even if Tarun assisted, even if Varun assisted, Tarun helped him to get the license and the ownership of the vehicle, my lordship.
Who is the issuing authority? Who is the issuing authority of a driving license?
Road transport
This is
officer.
the state.
In no, my lordships. But they have,
This is not the conclusive proof.
yes, my lordship, but they have made a statement that Varun has a previous history by acquiring the license, my lordship. But they forgot to acknowledge that.
This is history. This is today's history.
Much only, my lordship.
License.
Much only, my lordship, but they have forgotten to acknowledge that Tarun had helped him in a more way, my lordship. They are solely accusing Varun alone, my lordships. Much only, my lordships. And they have stated that the invocation of section 302 is legally valid, my lordships. But there is no collective term which imposes the constructive liability under the section 300 here, my lordships. It states that the offender or the person. There is no collective term here. Then how it could be invoked for Varun here, my lordships? And how it can be, how the bail can be cancelled based on that particular section, my lordships. And it is stated that they are treating him as an adult, my lordships. It has been stated by the
That's
letter.
proved. That's what. Since there is a government proof, it is a conclusive proof to declare Varun is a major.
Much obliged, my lordships, but the Varun statement says that he is 17 years old, my lordships. So there is a contradiction here, my lordships, and he was studying in a higher secondary school. So his other documents should also needed to be verified by the Junior Justice Board, my lordships. So there is a contradiction between the documents which has been submitted here, my lordship. So with the mere contradiction, how he could be tried before a criminal court, and the respondent who produced to Varun before the.
That's what they are requesting you to approach the council to put it asking Article 226. Writ of the showing you can ask.
Much obliged, my lordship, there is an alternative remedy is present here, my lordship. So we are approaching the court with an alternative remedy, my lordship. Much obliged, my lordship. These are the contents made by the petitions.
Thank you.
Much obliged, my lordship.
Permission to start questions. Greetings, the bench. The council feels very pity for the learned opponents for saving the Tarun by malafidely admitting himself as an offender. The lordship, from the starting itself, he is claiming Varun is not offender, Tarun is offender. And he is also claiming Tarun helped Varun to get the driving license. So, it should not be confirmed before the honest before the eyes of law. Your lordship, it is proved that from the starting of statement, that is admitted fact in the point number 7 in the Moot proposition itself, very clear. Snatchers came behind and tried to snatch a chain, and then the snatchers nonchalantly sped away. Here, your lordship, the nonchalantly is again and again summarized in this particular bench as my co-counsel.
This point you will learn at
Council,
In-
one question. why you have not registered either under section 34 or under section 109 IPC?
Your Lordship, the investigation is still pending. Whatever charges to be added is to be added by the magistrate. Immediate, Your Lordship. On the presumption that he and Tarun should be doing this particular murder.
So, Varun has been arrested.
Immediate, Your Lordship.
So, either he should have abetted the offence or should have shared the common knowledge. Why those sections not being included?
Immediate, Your Lordship. The following investigation, the police side will be including the following
So,
sections.
related to that, how an online person can be arrested?
Your Lordship, based on the Evidence Act, it is on section 65B, that is it is a primary evidence of electronic record, which is a CCTV footage claimed for the nearby shop where the incident is happened. It is a primary evidence to file the FIR immediately to search for the Tarun, Your Lordship. That is why the proceeding is started, Your Lordship. On the premature stage, the following stage will be adding the following sections from the guidance, Your Lordship. Your Lordship, we added the following rebuttals, Your Lordship. Opponent learned counsels content with the statement of Mesudas, Your Lordship. Your Lordship, from the statement of point number 7 in Moot Code, Marina was severely injured and she could not able to speak. From the statement of Mesudas, it is very clear she took the help of the passerby and called him and informed what all happened here. And the two men wearing the mask going on the bike and they dragged her chain and they rashly driving due to the force of torque. If the particular chain is not snatched, the bike will be down, and due to the centrifugal force, both will be fallen off. Here, the chain is snatched, and the stolen property is in the possession of Tarun. Your Lordship, on the day Tarun was caught, the stolen property will be produced before this court, Your Lordship, and the following argument proves that it is a dying declaration of Marina. It is to be admitted before this ISOP law. It is not the presumption or any other statement given to the police under 161 also, Your Lordship. It is also proved here from the point number 12. Karavallur police caught Varun and interrogated whatever happened in this scenario. Why you gave the bike? And they interrogated with him. It is also the statement 161 according to the learned opponents. But on point number 16. The court took the cognizance of Zena murder case and issued summons to the police side and the connected parties on the basis of Varun's statement. If the court is allowing the Varun statement in that particular case, why not in this case Marina's statement to be admissible before this court of law? And the next rebuttal should be, Your Lordship, due to the NCRB, I humbly submit the NCRB data of latest 2022, whereas the crime by the juveniles, that is the child conflict with law, it is increasing rapidly. Your Lordship, our Manastan, that is Tamil Nadu, stands top 3. To shamelessly say, it is stand top 3 in the offences committed by the juveniles. If they are not to be treated as adult and they are released on bail, they will followingly cause any other harms, Your Lordship. And it is also held in the judgment of Lalita Kumari, whereas there is an obligation mandates the police officer to record the statement as FIR whenever or whichever offences is caused, Your Lordship. Here, the criminal offence that is cognizable under the law, it is invoked under the section 166A, already dealt with my statements, that offence is kidnapping and abduction. Your Lordship, the parent of Zena is coming and complaining about missing of the child with a boy. Your Lordship, she gone with a boy to meet a boy. And here itself it proves there is a prima facie for missing of the girl. The minor can be kidnapped under the provisions. Your Lordship, just 1 minute, Your Lordship.
Yes, 866. Yes, you argue.
Your Lordship, under Article 370, Your Lordship, it is proved that the exploitation or transfer of a person includes subclass 4, where the offence involved the trafficking of a minor. Your Lordship, here the police can assume there is a missing of Zena. She is a transgender, she is a minor, she can be kidnapped, she can be trafficked for the sexual exploitations. And the careless mistake from the police side, they didn't even file an FIR. And this is the sir rebuttals argue before this bench. To add at the final touch, Your Lordship, under section 482, as it have a plenitude powers vested with the Honorable High Court, it should not be used usefully, Your Lordship. The statutory power has to be exercised sparingly on only at the rarest of rare cases. Under the Bachchan Singh judgment itself is very clear. If the court presumes it is a rare case, it should be invoking the inherent power under the section 482, not at all possible. Council feel pleasure to be argued.